Good morning all. So today we will be discussing on fundamental rights, directive principles of state policy and fundamental duties. From this, what are all the PYQs asked from fundamental rights, directive principles of state policy and fundamental duties? First question, 2024, which has been asked in the year 2024, which is also asked in the year 2021. There is right to privacy. Right to privacy is protected under which article of the Constitution? So whether it is Article 15, Article 19, Article 21, Article 29. From this we can understand one thing. What is that? Out of 100 questions which UPSC asks, from analyzing last 13-14 years of question paper, it's 100% sure that they are going to ask 40% of the question tough, 30% of the questions easy, 30% of the questions very tough. In this way, out of 100 questions, 40 questions. Out of 30%, 30 questions. Out of this, 30 questions. Means this type of questions will come under this percentage of the questions. If you want to clear the examination, out of 100, if you keep 50, there is high chance that 50 into 2, without any negative marking, you are going to get 100 marks. 100 marks is making you to clear prelims examination in general category. And in that 50 also, very easily you can get this 30. Correct. 30 into 2, 60 marks. So out of, this is equal to 100 by 200, which is called as 60. 60 marks out of 200 marks. 60 marks out of 200 marks. Means more 40 marks you have to work from this tough questions and very tough questions. From this tough questions and very tough questions. So from this you have to understand that what are all the easy questions? What are all the easy questions? 100% you should be in a position to keep correct answer. For example, this. Right to privacy is protected under which article of the Constitution of India? So whether Article 15 or Article 19 or Article 21 or Article 29. Asked two times. 2019 it was, 2021 it was been asked and 2024 it was been asked. So one question whereby it is easy. You know that Article 21 of the Constitution, which is called as right to life and liberty, which mainly talks about right to privacy also. In K. Puttaswamy case judgment, Justice Puttaswamy case judgment, the Supreme Court of India had iterated that right to privacy is also part of Constitution of India. Right to privacy is part of fundamental rights of the Constitution under right to life and liberty. These are the things which is easy. Now you see. 2023, a writ of prohibition, 2023 question, a writ of prohibition is an order issued by the Supreme Court to High Court. A government officer prohibiting him from taking a particular action, the Parliament or Legislative Assembly to pass a law on prohibition, the lower court prohibiting continuation of proceedings in a court, the government prohibiting it from following an unconstitutional policy. Another is a writ of prohibition. So we know that under Article 32 we have 6 writs. One is habeas corpus, quo warranto, mandamus, prohibition, certiorari and quo warranto also we discussed. So these are the 6 writs which are being part of the Article 32 of the Constitution. See, if you have clarity on this, another question, easy question 2023. Write about the writ of prohibition. ప్రొహిబిషన్ గురించి అడిగారు. సో ఆ 32 ఆర్టికల్లో ఉన్నటువంటి writsలో నుంచి ఒక క్వశ్చన్ 2023లో అడిగారు అండ్ ఆర్టికల్ 21 యొక్క ambit ఇంటర్ప్రిటేషన్ ఆఫ్ ఆర్టికల్ 21 వాస్ బీన్ ఆస్క్డ్ ఇన్ ద అండర్ 2024. సో ఫ్రమ్ దిస్ వీఆర్ అండర్స్టాండింగ్ దట్ if we properly study and if we properly understand this today's topics, fundamental rights, directive principles of state policy and fundamental duties, there is high chance of getting correct answer. Third question we will see. What is this? See, we know that the lower court prohibition, we are prohibiting lower court from exceeding its jurisdiction. So the higher court will tell that, hey, lower court, you are exceeding your jurisdiction, please be controlled, hence I am prohibiting you from going further. Is writ of prohibition. With reference to writs issued by courts in India, consider the following statements. Consider the following statements. Number 1, Mandamus. Mandamus will not lie. Means Mandamus will not depend, or Mandamus is not against a private organization unless it is entrusted with a public duty. What is Mandamus? Again, 2022. There is a question on writs. Means we have to first understand Article 32. What are writs? The same question is repeated in 2022. The same question is repeated in 2023, which means that UPSC have a framework. In that framework, they want to ask about writs. There is a question about writs. What is Mandamus? Mandamus is telling a public officer to do your duty. Or Mandamus will also tell to a private person who is doing a government contract to do your duty. The Mandamus is a writ whereby it will tell. The Mandamus is a writ whereby it will tell to the private organization. It will tell to the private organization, please, you are having public trust under you, you are having public funds under you, you are doing public good, still you have to do your duty. So Mandamus is not exclusive for the government officers only. Mandamus is for private people, Mandamus is for private organizations if they are working for public, if they are working with public money. Mandamus will not lie against a private organization unless it is entrusted with the public duty. Yes or no?
Yes.
Mandamus will not lie against a company even though it may be a government company. For government company, it will not be there. Why, sir? You have to understand that. Little bit knowledge. We have public sector undertakings. We have public sector undertakings. We have public companies. We have corporations. Corporations like National Thermal Power Corporation. We have corporations like National Hydro Power Corporation, corporations. NPCL, Nuclear Power Corporation of India, corporations. These are what? These are running on the motto of two things, welfare as well as profit. Whereas other company which is there, like company, like BSNL, Bharat Sanchar Nigam Limited, MTNL, which is Mahanagar Telecom Nigam Limited, MTNL. These are what? Companies. Companies will exclusively run on the motto of profit making. Will run on the motto of profit making. Whereas corporations which are under the control of public, which will be having two duties, which is called as welfare and profit. Whereas the same public sector undertakings which are established under the name of company, but it is under public sector like BSNL, MTNL, their motto only will be profit making. Third will be department, like Indian Railways. Indian Railways is what? Department. Department will be working under the motto of only welfare. That is the reason yesterday what happened? 2 general bogies were been added to each train. Extra 2 general bogies were been added to each train. Earlier, 2 front, 2 back. Only 4 general bogies used to be there. Now how many general bogies are there? 6. With general bogie, the government is not going to get any benefit. The government is going to get benefit by the AC coaches, or the government is going to get benefit by sleeper coaches. But the government is not going to get profit by general bogies. Why? Because general bogies, they will not buy ticket, only they will sit. But why they are increasing general bogies? Why they are increasing general bogies? Because it will help masses. Helping masses means what? Welfare oriented. So 3 departments are there in under public sector undertaking. One is corporation, other is department, other is company. Corporation, welfare as well as profit. Company, only profit. Department, only welfare. So Mandamus will not lie against a company even though it may be a government company. Yes or no? Third, any public-minded person can be a petitioner to move the court to obtain the writ of quo warranto. What is quo warranto? This we will discuss again, but understand that. So, they are asking you to have a proper command on writs. That is the reason there is a question on 2022, there is a question on 2023. Next. Again, now there is an issue happened. When Amit Shah had criticized or Amit Shah had told one particular thing with respect to B.R. Ambedkar, so BJP was being targeted by the Congress. Now the same BJP is targeting Congress, saying that Nehru was being given Bharat Ratna, Indira Gandhi was being given Bharat Ratna, and Rajiv Gandhi was being given Bharat Ratna. Later in 1990, the Bharat Ratna was being given to B.R. Ambedkar. So hence again in the news, Bharat Ratna award is in the news today. Number one. Number two, when this question was being asked in 2021, a case was being filed against Mohan Babu. Why? Because Mohan Babu, what he is doing, for all the award, in his movies also Padma Shri is writing. Then the court told that Mohan Babu, you should not use the title of government for your advertisement. You should not use the title which is conferred on you, should not be used for promotions. It is a title which is given because of your distinguished service, that's it. So hence the question of awards came. Hence in 2021 they asked it. Means what? Sometimes which are in the news, few times which are in the news will be replicated in the examination. Hence there was a question on Bharat Ratna, hence there was a question on Padma Shri, hence there was a question on Padma Bhushan. Consider the following statements in respect of Bharat Ratna and Padma Awards. Bharat Ratna and Padma Awards are titles under Article 18, Clause 1 of the Constitution. Padma Awards, it's 11 o'clock, please come on time, sit there. Padma Awards, which were instituted in the year 1954, were suspended only once. The number of Bharat Ratna awards is restricted to a maximum of 5 in a particular year. See, here we are not going to study about Bharat Ratna, but here we are understanding that why they asked in the year 2021. So 2021 there was an issue with respect to Padma Shri, hence the question was on Bharat Ratna as well as Padma Shri. Now in 2024 December what happened? Again the issue of awarding Bharat Ratna to Ambedkar, and there was a demand to give Bharat Ratna to Manmohan Singh. Now there is a demand to give Bharat Ratna to Manmohan Singh and P.V. Narasimha Rao, both of them. Hence again it is in the news. So we have to identify that. Oh, there is a question regarding Bharat Ratna. There is a question with respect to Padma Shri. There is a question with respect to Padma Bhushan. There is a question with respect to Padma Vibhushan. Then we have to read that and we have to make our notes. We should not read who got Bharat Ratna. What are the provisions with respect to Bharat Ratna? What is the eligibility to get Bharat Ratna? In the history, how many times Bharat Ratna was been not given or Padma Awards were been not given? You have to come to a conclusion. So hence the question. But under which article? 18. What is 18? Abolition of titles. Again a question come. Abolition of titles. Then why we are giving titles called as Padma Shri, Padma Vibhushan, Padma Bhushan, Bharat Ratna or Ashok Chakra, Paramvir Chakra? Abolition of titles, no? Honor. Abolition of titles. Then why we are giving? Article 18 is telling that abolition of titles. Then how we are giving Padma Bhushan, Padma Shri and Bharat? These all awards, why we are giving?
Service to country. Merits.
So, abolition of titles only which are hereditary in nature. Abolition of titles which are given by foreign players. But if you want to take that award, you have to get the permission from the president. If not, that award should not be there. If not, that award will be abolished. So, two circumstances. Number one, hereditary awards, hereditary titles like what? Raj Bahadur, Jamindar. This type of titles or this type of awards are not allowed. Next question. A legislation, 2021. A legislation that confers on the executive or administrative authority an unguided and uncontrolled discretionary power in the matter of application of law violates which one of the following articles of the Constitution of India? Think and tell me. A legislation that confers on the executive or administrative authority an unguided and uncontrolled discretionary power in the matter of application of law violates which one of the following articles? A legislation that confers on the executive or administrative authority an unguided, uncontrolled discretionary power. Right to equality. There should be guided, there should be controlled discretionary power. There should not be unguided and uncontrolled discretionary power. In English language it is there. Unguided and uncontrolled. 14. Why? Because Article 14 is telling what? Right to equality. So here we are not going to discuss about this question. Few times we have to understand the words also. Unguided, uncontrolled, unguided, uncontrolled will lead to what? Unguided, uncontrolled will lead to what? Unguided, uncontrolled will lead to excessive discrimination. Excessive discretion. Excessive arbitrariness. When there is excessive arbitrariness, when there is excessive discretion, whether there is a chance of violation of equality? So that word's meanings we have to get. In this question, everything is rotating around what? An unguided and uncontrolled discretionary power. Which one of the following categories of fundamental rights incorporates protection against untouchability as a form of discrimination? Right against exploitation, right to freedom, right to constitutional remedies, and finally, right to equality. 14 to? Easy question only. Other than the fundamental rights, which of the following parts of the Constitution of India reflect the principles and provisions of Universal Declaration of Human Rights? What? Okay, preamble means fundamental rights కాకుండా ఇంకా ఎక్కడెక్కడ యూనివర్సల్ డిక్లరేషన్ ఆఫ్ హ్యూమన్ రైట్స్ ఎంబెడెడ్ అయి ఉంది? ఎక్కడెక్కడ ఎంబెడెడ్ అయి ఉంది? ప్రియాంబుల్లో ఉంది, డిపిఎస్పిలో ఉంది, మరి ఫండమెంటల్ డ్యూటీస్లో ఉందా లేదా? టెల్ మీ. Other than fundamental rights, which of the following parts of the Constitution of India reflect the principles and provisions of Universal Declaration of Human Rights? General human rights. So we no need to know about Universal Declaration of Human Rights. So general human rights other than fundamental rights. Anyhow, fundamental rights lo human rights unnai, preamble lo human rights unnai. For example, social equality, economical equality, political equality, these all are there. Then in preamble it is there. In directive principles of state policy also there. Article 40 special provisions for weaker sections is there. Then fundamental duties lo unnaya leva? Fundamental duties lo unnaya leva? 192, 2, 193 and 1213. Yes, fundamental duty also. అప్పుడు మన ఫండమెంటల్ డ్యూటీస్ అన్ని గుర్తుంచుకోవాలి. యూనివర్సల్ బ్రదర్హుడ్ని మనం ప్రమోట్ చేస్తామా లేదా? యూనివర్సల్ బ్రదర్హుడ్ ఈజ్ అ పార్ట్ ఆఫ్ fundamental duties, and universal brotherhood is a part of human rights. Everyone should have a universal brotherhood with another man. There is a need for fraternity, there is a need for universal brotherhood. Which article of the Constitution of India safeguard one's right to marry the person of one's choice? Article 1921. Article 21 means what you have to identify. In yesterday's day one historical underpinnings, at least we have to remember, at least we have to memorize. But in fundamental rights, directive principles of state policy, fundamental duties, if you understand, there is higher chance of getting positive marks. There are higher chances of getting less negative marks. But for that, what we have to do, we have to get the command on the FD, FR, DPSP. Next question we will say. Under the Indian Constitution, concentration of wealth violates what? Under the Indian Constitution, concentration of wealth If you remember Directive Principles of State Policy, in that one article is there which tells that there should be redistribution of resources, the concentration of wealth should not be there. So if the concentration of wealth is happening, it means it is violating what? Directive Principles of State Policy. One of the important directions given to the state is, please don't make the people to have concentration of wealth. Rather than that, what you have to do? You have to redistribute the wealth. సో డైరెక్టివ్ ప్రిన్సిపల్స్ ఆఫ్ స్టేట్ పాలసీ యొక్క ముఖ్యమైనటువంటి ఉద్దేశం ఏంటంటే, డిపిఎస్పి యొక్క ముఖ్యమైనటువంటి ఉద్దేశం ఏంటంటే, ఎప్పుడైనా కూడా స్టేట్ చేసేటటువంటి పాలసీ అందరికీ సమానంగా యూజ్ అయ్యే విధంగా ఉండాలి, కానీ ఒకటే సెక్షన్ ఆఫ్ పీపుల్కి యూజ్ అయ్యే విధంగా ఉండకూడదు. అలా యూజ్ అయ్యేటట్టు ఉంటే ఏమవుతుందంటే కాన్సన్ట్రేషన్ ఆఫ్ వెల్త్ అవుతుంది. ఎప్పుడైతే కాన్సన్ట్రేషన్ ఆఫ్ వెల్త్ అవుతుందో ఖచ్చితంగా ఒక సెక్షన్ ఆఫ్ పీపుల్కి వెల్త్ అందుబాటులో ఉండదు. ఒక సెక్షన్ ఆఫ్ పీపుల్కి వెల్త్ అందుబాటులో ఉండకపోతే మనం సోషలిస్టిక్ సొసైటీ ఎస్టాబ్లిష్ చేయలేము. డైరెక్టివ్ ప్రిన్సిపల్స్ ఆఫ్ స్టేట్ పాలసీ మెయిన్ ఉద్దేశం ఏంటి? సోషలిస్టిక్ ప్రిన్సిపల్స్ ఆర్ పార్ట్ ఆఫ్ అవర్ కాన్స్టిట్యూషన్. సో దాని ద్వారా దేన్ని వయోలేట్ చేస్తున్నట్టు? రైట్ టు ఈక్వాలిటీ కాదు, రైట్ టు ఫ్రీడమ్ కాదు, కాన్సెప్ట్ ఆఫ్ వెల్ఫేర్ కాదు. దేన్ని మనం వయోలేట్ చేసినట్టు? విచ్ పార్ట్ ఆఫ్ ద కాన్స్టిట్యూషన్ ఆఫ్ ఇండియా డిక్లేర్స్ దట్ ఐడియల్ ఆఫ్ వెల్ఫేర్ స్టేట్? DPS. So what is the difference, sir? Understand this. Fundamental rights only talks about individual rights. Fundamental rights main motto is protection of individual rights, and directive principles of state policy main motto is promoting collective welfare, promoting collective development, promoting డెవలప్మెంట్ ఆఫ్ ద సొసైటీ. సో కలెక్టివ్నెస్ ఉండేదేమో డైరెక్టివ్ ప్రిన్సిపల్స్ ఆఫ్ స్టేట్ పాలసీ మాట్లాడుతుంది. ఇండివిజువల్ రైట్ గురించి ఎవరు మాట్లాడుతుంది? ఫండమెంటల్ రైట్స్ మాట్లాడుతుంది. సో వెన్ ఎవర్ దెర్ ఈస్ ఎ ఇండివిజువల్ రైట్, యూ హ్యావ్ టు బ్లైండ్లీ బిలీవ్ దట్ ఇట్ ఈస్. విత్ రిఫరెన్స్ టు ద ప్రొవిజన్స్ కంటైన్డ్ ఇన్ పార్ట్ 4, పార్ట్ 1 ఈజ్ యూనియన్ అండ్ టెరిటరీ, Part 2 is citizenship, Part 3 is fundamental rights, Part 4 is directive principles of state policy, Part 4A is Part 1 is union and territory, 1, 2, 3, 4. Then Part 2 is 5 onwards, which is citizenship, 5, 6, 7, 8, 9, 10, 11. Then Part 3 is 12 to 35, and Part 4 is 36 to 51, and Part 4A is 51A. So till date we are going to complete part 1, 2, 3 and 4. With reference to provisions contained in part 4 of the Constitution of India, which of the following statements are correct? They shall be enforced by the court. Directive principles of state policy ni కోర్టులు ఎన్ఫోర్స్ చేయగలవా? జస్టిషియబుల్ ఆర్ నాన్ జస్టిషియబుల్? They shall be enforceable by court? No. They shall not be enforceable by any court?
Yes.
The principles laid down in this part are to influence the making of laws by the state. So how many are correct? 2. In the context of India, which one of the following is correct relationship between rights and duties? Rights are correlative with duties. Rights are personal and hence independent of society and duties. Rights, not duties, are important for the advancement of the personality of the citizen. Duties, not rights, are important for the stability of the state. Think and tell me. హక్కులతో పాటు బాధ్యతలు కూడా అంటే ఏంటి? హక్కులకి బాధ్యతలకి రెండిటికి కోరిలేషన్ ఉంటుంది. సో హక్కులు ఒకటే పనిచేయదు, హక్కులతో పాటు బాధ్యతలు ఉంటాయి. ఎప్పుడైతే హక్కుల గురించి మాట్లాడుతున్నావో అదే తరుణంలో బాధ్యతల గురించి కూడా మాట్లాడాలి. హెన్స్ ఆన్సర్ ఇస్ వాట్? రైట్స్ ఆర్ కోరిలేటివ్ విత్ డ్యూటీస్. ఈజీ ఓన్లీ. దీస్ ఆర్ PYQs with respect to fundamental rights, fundamental duties and DPS. So one thing we came to a conclusion from this. Day 2లో ఉన్నటువంటి సిలబస్, అది ఫండమెంటల్ రైట్ కావచ్చు, డైరెక్టివ్ ప్రిన్సిపల్స్ ఆఫ్ స్టేట్ పాలసీ కావచ్చు, లేకపోతే ఫండమెంటల్ డ్యూటీ కావచ్చు. ఈ 3 ప్రీవియస్ ఇయర్స్ క్వశ్చన్స్ మనం చూస్తే, if we have a proper command, if you remember the articles, if you understand the articles, you can answer it correctly. And which is damn sure that from fundamental rights, from fundamental duties, from directive principles of state policy, 80% లో 3 ప్రశ్నలు అడుగుతాడు. There will be 3 questions. అంటే 100 క్వశ్చన్స్లో నుంచి 3 క్వశ్చన్స్కి మీరు ఆన్సర్ చెప్పినట్టే. ఈరోజు కనుక మీరు ఫండమెంటల్ రైట్స్, డైరెక్టివ్ ప్రిన్సిపల్స్ ఆఫ్ స్టేట్ పాలసీ అండ్ ఫండమెంటల్ డ్యూటీస్ కంప్లీట్ చేసుకుంటే. సో ఐ విల్ డూ ద క్విక్ రివిజన్, how to remember the articles and what are the things which are part of articles. Fundamental rights. Article 12 will talk about definition of state. అంటే ఫండమెంటల్ రైట్స్ ఎన్షూర్ చేసేటప్పుడు ఎవరు ఎన్షూర్ చేయాలి? స్టేట్ ఎన్షూర్ చేయాలి. ఎవరు స్టేట్? ఒక గవర్నమెంట్ కానీ, గవర్నమెంట్ మెషినరీ కానీ, గవర్నమెంట్లో పనిచేసేటటువంటి పీపుల్ కానీ, ఆర్ గవర్నమెంట్ ఫండెడ్ పీపుల్ కానీ, ఆర్ గవర్నమెంట్ ఆర్గనైజేషన్ విచ్ ఈస్ గివింగ్ ఆన్ కాంట్రాక్ట్ టు ద ప్రైవేట్ పీపుల్ ఆల్సో కాల్డ్ అస్ స్టేట్. సో ఆర్టికల్ 12 ప్రకారంగా స్టేట్ ఎవరు అని అంటే గవర్నమెంట్ డిపార్ట్మెంట్ ఎలాగూ, పార్లమెంట్ ఎలాగూ, సుప్రీంకోర్టు ఎలాగూ, హయ్యర్ జ్యుడిషియరీ ఎలాగూ. ఇక్కడ ఒక తేడా ఉంటుంది. యూ షుడ్ ఐడెంటిఫై వెరీ కేర్ఫుల్లీ. స్టేట్ అంటే అండర్స్టాండ్ దిస్, ఎగ్జిక్యూటివ్ ఈజ్ అ స్టేట్, లెజిస్లేచర్ ఈజ్ ఆల్సో స్టేట్. ఎగ్జిక్యూటివ్, దట్ ఈస్ పర్మనెంట్ ఎగ్జిక్యూటివ్, సివిల్ సర్వెంట్స్ ఆర్ స్టేట్. ప్రైవేట్ కాంట్రాక్టర్స్ who are working for the government are also state. Contract employees are also state. Contract employees also state. Or who is getting funded by the government in private organization, they are also called as state. Plus judges, judicial administration మాత్రమే స్టేట్. జుడిషియల్ అడ్మినిస్ట్రేషన్ మాత్రమే స్టేట్, జుడిషియల్ జడ్జిమెంట్స్ కాదు. ఆర్ గెటింగ్ మై పాయింట్? జుడిషియల్ అడ్మినిస్ట్రేషన్, జడ్జ్ హిమ్సెల్ఫ్ is also called as what? State. Judicial administration, judicial administrative system is called as state. But judgment which is coming out is not called as state. For example, ఒక జడ్జిమెంట్ ఇచ్చాను, మరణశిక్ష విధించండి, వయలేషన్ ఆఫ్ ఆర్టికల్ 21, రైట్ టు లైఫ్ అండ్ లిబర్టీ, చంపేసేయండి. So complete violation of Article 21. Then how a judicial judgment will be violating fundamental rights of an individual? So state means it is only the judicial administration, the members of judiciary, but not the judicial pronouncements. Judgments are not called as state. Judges and the judicial administration is called as state. So this comes under Article 12. Part 3. 12 to 35. In the classroom itself, we will try to remember it. 12 to 35. Magna Carta of India, the cornerstone of the Constitution. Magna Carta of India and the cornerstone of the Constitution. వాట్ ఈజ్ మాగ్నా కార్టా? మొట్టమొదటిసారిగా ప్రపంచంలో ఒక రాతపూర్వకంగా చేసినటువంటి అగ్రిమెంట్ పేరే మాగ్నా కార్టా. అలాంటిది ఫండమెంటల్ రైట్స్ కూడా మనం రాతపూర్వకంగా చేసుకున్నాం మన కాన్స్టిట్యూషన్లో. హెన్స్ ఇట్ ఈస్ కాల్డ్ as మాగ్నా కార్టా ఆఫ్ ఇండియా. Fundamental rights and directive principles of state policy together called as conscience of the Constitution. Fundamental rights aims at a government of laws but not government of men. Kim Jong-un of North Korea is the government of men. ఆయన నోట్లో నుంచి ఏదొచ్చిందో అదే లా, అదే చట్టం. కానీ మన దగ్గర ఏంటి లా, ఏంటి చట్టం? ఏదైతే రాసామో, ఏదైతే రాసి పెట్టుకున్నామో అది మాత్రమే చట్టం. Fundamental rights aims at government of laws and not on men. And Article 14 to 18 is right to equality. Article 19, 20, 21, 22 is called as what? Right to freedom. 23, 24 is called as what? Against exploitation. And 25, 26, 27, 28 is called as what? Right to freedom of religion. Then 29, 30 is what? Cultural and linguistic rights. Right to cultural and educational rights. Right to property, Article 31. Anyhow, it was been removed. And right to constitutional remedies is Article 32. So 44th Constitutional Amendment Act had removed 44th, don't get confused, 44th Constitutional Amendment Act had removed right to right to property from fundamental rights and placed in legal right under Article 300 Clause A. And now right to property is not a fundamental right. So at present, how many fundamental rights we have? 1, 2, 3, 4, 5, 6. 31 is no more. Definition of state. Executive, legislature, state executive, state legislature, all local authorities, like who? Gram Panchayat, mayor, ward members, corporators, municipalities, statutory and non-statutory authority. Even a private body or an agency working as an instrument of state falls within the meaning of the state. Under Article 12, actions violating fundamental right by state can be challenged in any courts. Here I didn't mention, but keep in mind that judiciary, judicial administration, judicial body is also state except judicial judgment. This is Article 12. Article 13. All laws that are inconsistent with or in derogation of any of the fundamental rights shall be void. అంటే ఏ చట్టమైనా కూడా చేసినప్పుడు అది ఫండమెంటల్ రైట్ని వయోలేట్ చేసినట్టయితే ఆ చట్టాన్ని మనం నల్ అండ్ వాయిడ్ లాగా చెప్పొచ్చు. దట్ ఈస్ కాల్డ్ as Article 13. So judicial review comes under which article? 13. Listen. 13. Whereas the constitutional remedies with respect to review, when we reviewed it and there is a violation of fundamental right, then there will be a remedy. And that remedy will be present in which article? రివ్యూ చేసేది ఆర్టికల్ చూపించి 13 చూపించి, రివ్యూని చేసే అధికారం దేని చూపించి, ఏ నెంబర్ని చూపించి, 13వ నంబర్ చూపించి రివ్యూ చేస్తాము. రివ్యూ చేసినప్పుడు ఇది ఫండమెంటల్ రైట్ వయోలేట్ చేస్తున్నామని చెప్పేసి ఒక కంక్లూజన్కి వస్తాము. మరి వయోలేట్ జరిగింది కాబట్టి ఇప్పుడు ఎలా కాపాడుకోవాలి అంటే ఒక మెడిసిన్ వేయాలి. అదేంటంటే రెమెడీ. అది ఏ నెంబర్లో ఉంది అని అంటే 32లో ఉంది. లైక్ దట్ ఇట్ ఈస్. సో డయాగ్నోసిస్ 13, ట్రీట్మెంట్ 32. దిస్ ఇస్ సింపుల్. Whether the disease is there or not, diagnosis happens under 13 and the treatment is provided under 32. If treatment is not there, then it is unconstitutional. So there is a chance for treatment if it is unconstitutional. There is a chance for treatment if it is unconstitutional, if it is violating fundamental right. If treatment is also not possible, 100% it is unconstitutional, null and void. Article 32, High Court can declare law invalid. 13 is exclusive having the power. Then what is the difference, sir? See, understand. 13 and 32 exclusively check whether it is violating fundamental rights or not. But High Court, Article 226, it checks not only fundamental right, not only any constitutional right, but also any law. అది లాని ఫాలో అవుతుందా లేదా అని రివ్యూ చేసే అధికారము హైకోర్టు దగ్గర ఉంటుంది. ఓన్లీ ఫండమెంటల్ రైట్ని ఫాలో అవుతుందా లేదా అనే హక్కు సుప్రీంకోర్టు దగ్గర ఉంటుంది. సో 2 things I am telling you. So Supreme Court will be having the power to check whether the law which is made is violating fundamental right or not. బట్ హైకోర్టు దగ్గర ఉన్నటువంటి ఆర్టికల్ 226 ఏమని చెప్తుందనంటే ఫండమెంటల్ రైట్ వయోలేట్ అయినా సరే, కాన్స్టిట్యూషనల్ రైట్ వయోలేట్ అయినా సరే, స్టాట్యుటరీ రైట్ వయోలేట్ అయినా సరే, ఇవన్నీ ఎక్కడ ఉంటాయి అని అంటే హైకోర్టు పరిధిలో ఉంటుంది. సుప్రీంకోర్టు పరిధిలో ఏముండదు. ద నార్మల్ ఆర్డినరీ లా ఈజ్ రివ్యూడ్ ఆర్ నాట్ ఈజ్ నాట్ దేర్ అండర్ సుప్రీం కోర్ట్, బట్ ఆర్డినరీ లా ఈజ్ బీన్ రివ్యూడ్ ఈజ్ ప్రెసెంట్ ఇన్ వేర్? Permanent law enacted by Parliament of State Legislature, temporary law like ordinance, these all will be checked. Ambit of law. Next is Article 14. So what you understood, what is the difference between Article 13 and Article 14? Inconsistent or derogatory with the laws of fundamental right, then it will be declared null and void. And that law which is being declared null and void can be given remedy by following Article 32. 14. Right to equality. Under right to equality, we have 2. One is called as equality before law, other is called as equal protection of law. Equality before law, simple ఒకటే ఈక్వాలిటీ బిఫోర్ లా. ఏ సర్కమ్స్టాన్సెస్లోనైనా సరే అందరినీ సమానంగా చూసేదేంటి? ఈక్వాలిటీ బిఫోర్ లా. ఏ సందర్భంలోనైనా ఏ ఎన్విరాన్మెంట్లోనైనా సరే మనం ఒకటే విధానంలో ఇఫ్ యు సీ ఆల్ ద పీపుల్ ఇర్రెస్పెక్టివ్ ఆఫ్ దేర్ స్టేటస్, ఇర్రెస్పెక్టివ్ ఆఫ్ దేర్ బర్త్, ఈక్వల్లీ ఈజ్ కాల్డ్ అస్ equality before law. Equal protection of law. When they are equal, then only we will be seeing equally. When they are unequal, we will be seeing unequally. That is the major difference between equality before law and equal protection of law. ఏ సందర్భంలోనైనా మనం సమానంగా చూస్తే దాన్ని ఏమనంటాం మనం? ఈక్వాలిటీ బిఫోర్ లా. ఏ సందర్భంలోనైనా సమానంగా ఉంటేనే సమానంగా చూస్తాము, అసమానంగా ఉంటే అసమానంగా చూస్తాము అన్నదేంటి? ఈక్వల్ ప్రొటెక్షన్ ఆఫ్ లా, విచ్ ఇస్ కాల్డ్ as absence of special privileges, equality of treatment under equal circumstances, equal subjugation of all to ordinary law, similar application of same laws to all persons who are similarly situated. So the major difference which you have to understand between equality before law and equal protection of law, ఏ సందర్భంలోనైనా ఏ సిట్యువేషన్లోనైనా సరే మనం అందరినీ సమానంగా చూస్తే దట్ ఈస్ కాల్డ్ as equality before law. According to the equals, the treatment will be equal. If the people are unequal, then the treatment will be unequal. It will be coming under equal protection of law. The concept of equality before law is an element of the concept of rule of law. ఆ రూల్ ఆఫ్ లా అందరికీ సమానంగానే ఉంటుంది. రిచ్ పర్సన్ మర్డర్ చేసినా సరే, పూర్ పర్సన్ మర్డర్ చేసినా సరే అందరికీ సమానమైనటువంటి శిక్ష పడాల్సిందే, రూల్ ఆఫ్ లా. ద ఎగ్జాంపుల్ ఆఫ్ ఈక్వాలిటీ బిఫోర్ లా ఈజ్ వాట్? రూల్ ఆఫ్ లా. ద ఎగ్జాంపుల్ ఫర్ ఈక్వల్ ప్రొటెక్షన్ ఆఫ్ లా ఈజ్ అఫర్మేటివ్ లా. The example of equal protection of law is affirmative law. What is affirmative law? Reservations. When we are giving reservations means whether we are treating all equally or we are treating unequally. We are treating unequally. Why? Because few people are cut off is less, few people cut off is more. Then why we are treating unequally? Why? Because they are not equal. So example for equal protection of law is affirmative law, and the example of equality before law is rule of law. First statement, equality before law talks about rule of law. Equal protection of law talks about affirmative law. Both the statements are correct, both the statements are wrong. Both the statements are correct. Absence of arbitrary power. No man can be punished except for a breach of law. Equality before the law. Constitution is a result of rights of the individual. Constitution is source of individual rights. Rule of law is basic feature and cannot be amended. At the same time, equality before law is also a basic feature. So there is a need for affirmative laws till they become equal. This belongs to right to equality. Right to equality. Article 14 mainly talks about two things: equal protection of law and equality before law. Equality before law, irrespective of the situation, irrespective of the circumstances, when the people are treated equally is called as equality before law. No, equals will be treated equally and unequal will be treated unequally is called as Article 15. Article state shall not discriminate based on 5 grounds. What are the grounds? Religion, race, caste, sex, or place of birth. But understand this. Yellow color only. ఈ 5 సందర్భాలు తప్పించి మిగతా ఏ సందర్భాలలోనైనా కూడా స్టేట్ దగ్గర పవర్ ఉంటుంది డిస్క్రిమినేషన్ చేయడంలో. ఎకానమీ ఉందా? క్లాస్ ఉందా? సో దెర్ ఈజ్ ఎ ఛాన్స్ టు డిస్క్రిమినేట్ ఆన్ ద బేసిస్ ఆఫ్ క్లాస్. దెర్ ఇస్ ఎ ఛాన్స్ టు డిస్క్రిమినేట్ బేస్డ్ ఆన్ క్లాస్. At is first one is what? Religion, race, caste, sex, or place of birth. Article 15, which is called as Prohibition, discrimination on the grounds of 5 is not allowed by the state. Only. What are those 5? Religion, race, caste, sex, place of birth. Economy, yes, we can discriminate. Economy, yes, we can discriminate. అలా ఇంకేముండొచ్చు ఎకానమీ కాకుండా? Language. Education status, very good. So based upon the educational status we can, based upon the language we can, based upon the economy we can, based upon the political status we can. But state cannot discriminate in any context on these 5 grounds. Only of religion, race, caste, place, or any of them is subject to any disability, liability, restriction, access to shops, public restaurants, hotels and places of worships. They should not be discriminated. 4 exceptions to non-discrimination. State permitted to make special provisions for women and children. Advancement of any socially and educationally backward classes. Admission of any socially and educational people to the government colleges or schools or government institutions. Article 16. If there is a question, according to fundamental rights, state are allowed to discriminate on the grounds of religion, economy, age, race. Economy and age. So, state is allowed to discriminate on the grounds of economy and age. That is the reason senior citizen or children, discrimination means positive, it can be positive, it can be negative. But there cannot be positive, negative on religion. There cannot be positive, negative on caste. There cannot be positive treatment and negative treatment based upon sex. Article 16. Equality of opportunity in public employment. In matters of employment, no citizen can be discriminated against or be ineligible for any employment or office under the state on grounds only religion, race, caste, sex, descent, place of birth or residence. How many grounds are there? 1, 2, 3, 4, 5, 6 or 7. Place of birth or residence, same. There should not be any discrimination with respect to providing opportunities with respect to public employment in how many grounds? 6 grounds. Discrimination is not allowed other than 5 grounds. Other than 5 grounds. ఈ గ్రౌండ్స్లో నుంచి అడుగుతాడు. అంటే కాన్స్టిట్యూషనే చాలా క్లియర్గా చెప్పిందన్నమాట. ఈ 5 గ్రౌండ్లు తప్పించి మీరు ఏ గ్రౌండ్లోనైనా డిస్క్రిమినేషన్ చేసుకోవచ్చు. కాన్స్టిట్యూషన్ చాలా క్లియర్గా చెప్పింది, పబ్లిక్ ఎంప్లాయ్మెంట్లో మీరు డిస్క్రిమినేషన్ చేయకూడదు ఈ 6 తప్పించి. ఏంటి 6 మళ్ళీ? రిలీజియన్, రేస్, కాస్ట్, ప్లేస్ ఆఫ్ బర్త్, సెక్స్ అండ్ డిసెంట్. ఓన్లీ ఈజ్ ఇంపార్టెంట్. పార్లమెంట్ క్యాన్ ప్రిస్క్రైబ్ రెసిడెన్స్ యాజ్ ఎ కండిషన్ ఫర్ సర్టన్ ఎంప్లాయ్మెంట్ లైక్ లోకల్ రిజర్వేషన్స్. State can provide reservation in favor of any backward classes. Law can provide incumbent office related to religious institutions. State permitted make a provision for reservation up to 10% of reservation for economically weaker section. In this way, there should not be any discrimination based upon 6 grounds. If not, there can be discrimination in public employment. In the 5 grounds, there should not be any discrimination based upon these 5 grounds. If not, there can be discrimination. For general discrimination, 5 grounds. For public employment discrimination, 6 grounds. 17. Abolition of untouchability. Yes, abolition of untouchability. And forbids the practice in any form. Untouchability Offences Act 1955 amended and renamed as Protection of Civil Rights Act of 1955. Untouchability, Mysore High Court told practice as it had developed historically in the country. So what is this? Supreme Court told that Article 17 is not just physical untouchability, it is mental untouchability also. So untouchability means not just a physical untouchability, the untouchability can also be a mental untouchability or a psychological untouchability is also regarded as untouchability. Like what? A discriminatory treatment or ill treatment or a negative treatment or a treatment of contempt or a treatment of hatred is also called as untouchability. Supreme Court rule. So Article 17 is abolition of untouchability and 18 is abolition of titles. Abolition of titles. Makes 4 provisions. Prohibit the state from conferring any title except military or academic. State ivadu. Government titles ivadu except military and academic. ఇంకా ఎందులోనూ గవర్నమెంట్ ఇవ్వడానికి లేదు. ఇవ్వాలి అంటే కాన్స్టిట్యూషనల్ అమెండ్మెంట్ యాక్ట్ జరగాలి. 2, సిటిజన్ ఆఫ్ ఇండియా ఫ్రమ్ యాక్సెప్టింగ్ ఎనీ టైటిల్ ఫ్రమ్ ఫారెన్ స్టేట్ లైక్ నైట్హుడ్. Sir, then Oscar award, sir. For Oscar award, they have to take the permission. So, not a blatant abolition. It is abolished. But if you want to take, you have to take the permission from the President of India. It can be Oscar. It can be Nobel Prize. Directly you will not get. It means you are going to get through a approval from the President of India. Other awards also abolished. But if I want to get, I can get through permission from the President of India. Why? Because every right is not absolute. Every right is qualified. It changes according to the case to case. A foreigner holding any office of profit or trust under the state cannot accept any title from the foreign state without the consent of the president. ఒక ఫారినర్ ఇండియాలో పనిచేస్తున్నాడు. అతను ఇండియాలో పనిచేస్తున్నప్పుడు ఒక ఫారెన్ కంట్రీ ఆయనకు ఒక అవార్డు ఇద్దాం అనుకుంది. అప్పుడు నువ్వు తీసుకోవాలి అంటే మళ్ళీ ఎవరు పర్మిషన్ అవసరము? ప్రెసిడెంట్ ఆఫ్ ఇండియా. 3rd condition. First condition, military and administrative can be given by the state itself. Other than that, the state is not allowed to confer. Number 2, any Indian who is getting award from international, then he is not allowed to get it. If he want, then he should get permission from president. 3rd, a foreigner who is working in the country and he got award from the foreign country, then if he want, then he should get the permission from the President of India. 4th, holding any office or profit under the state to accept any present emolument or office from or under any foreign state without the consent of the president. Hereditary titles of nobility like Maharaja, Raja Bahadur, Rai Bahadur, completely banned. 1996 Supreme Court held constitutional validity of the national awards, Bharat Ratna, Padma Shri, Padma Bhushan and Padma Shri. However, they should not be used as suffixes or prefixes to the names. Otherwise, they should forfeit the awards. Padma Shri, ade Babu Mohan antuna. Mohan Babudi, he used it like anything. So the issue came up to 2021. Hence, they asked in 2021 mains. Mohan Babu went up to Supreme Court. Why I should not use? It is conferred on me. It is a pride to me. Then the Supreme Court of India, when it is a pride to you, then there is no need to showcase it. You are advertising it, you are marketing it, you are promoting it commercially. You can use it when you can use it, when you are doing a public function. You can use it when you are doing any social activity, not for your private gains called as cinema. Again, Bharat Ratna issue is there. Now there is a demand for P.V. Narasimha Rao, now there is a demand for Manmohan Singh, and there is a question of Bharat Ratna to B.R. Ambedkar. So again we can expect a question of Article 18. So in 4 circumstances, abolition. Number 1, state cannot confer except academic and military. Second, Indian who is getting foreign award is not allowed unless he get a permission from president. 3rd, a foreign who is working in India is getting award from foreign, he can get it with the permission of president. 4th, Raj Bahadur, Rai Bahadur, Jamindar, these all are been completely banned. Not at all allowed. Not at all allowed. This is Article 18 of the Constitution. So 14 is right to equality. Means what? Equality before law, equal protection of law. Article 15, 5 grounds. Article 16, 6 grounds. Article 17, abolition of untouchability, not only physical but also psychological and mental. Article 18 is abolition of titles in 4 circumstances. Number 1, the awards are allowed only in academic and military by the state. If not, it is not allowed. Number 2, local man, international award, or international man, international award. 4th, not at all allowed. What type of is not at all allowed? Raj Bahadur, etc. And the Padma Shri, the Padma Bhushan, Padma Vibhushan, these are been not allowed to use at prefixes and suffixes. Now you see, national awards instituted in 1954, 2 times, from 1977 to 1980. 1997 to 1980, 3 years, Janta government was against conferring the awards. So first time the awards were been not given. Which time? 1977 to 1980 under the government of Janta. Then second time, 1992 to 1993, awards were been not given. Why? Because the issue was been sub judice to Supreme Court of India. So these 2 circumstances, national awards were been not given. And every year Bharat Ratna will be allowed to give only 3. How many Bharat Ratnas will be given? Only 3. Right to freedom. Article 19. Remember this. Speech and expression. Right to freedom of speech and expression. Assemble, association, movement, Sasuma, RP, this is residence and profession. Sasuma for sale. Sasu, S-A-A. Speech and expression, assemble, association, movement, residence and property. Article 19 talks about 6 rights. Speech and expression. Assemble, association, movement, residence and property. Profession. Residence, movement, association, assemble, speech and expression. 7 rights. 44th Constitutional Amendment Act 1978 had removed right to property. Only state action, not private individuals. These are only state. Private cannot. Means I cannot stop anyone's speech. I cannot stop anyone's assemble. I cannot stop anyone's association. But who can stop? State can stop. If a speech is violating any person's fundamental right, we cannot oppose the speech. If any assemble is against any individual's right, then we cannot oppose the association or assemble. But the speech and expression, if it is violating integrity of the nation, if it is violating the good relationship with the foreign relations, then the state will be having the power to stop it. So SAAMRP is not absolute, it is qualified. However, private people have their rights. Private people can have the right. I can criticize any man. I can criticize the government. No one can stop. But my criticism can be stopped by the state if and only if it is going to violate the foreign relations or diplomacy or relationship with the foreign countries, or integrity is being impacted or security is impacted. Then only I can go for not allowed. So Article 19, right to freedom. Freedom of speech and expression. Propagate one's views as well as views of others. Freedom of press. Freedom of commercial advertisements. Freedom against tapping of telephonic conversion. Again, this is current affair. In the state of Andhra Pradesh and in the state of Telangana, what happened? The previous governments had tapped the telephones of political leaders, and they got the information with respect to political. So whether it is violation of freedom of speech and expression, obviously it is violation of freedom of speech and expression. That is also not allowed. Right against tapping of telephonic conversation. Right to telecast, no monopoly of government. Anyone can telecast. Right against bandh, called by political party or organization. Bandh is not a fundamental right. So no one can call for a bandh. It cannot be an assembly, it cannot be an association. Right to know about government activities, freedom of silence, right against imposition of pre-censorship, most important. Right to demonstration or picketing, but not right to strike. Right to strike is not a fundamental right. Right to bandh is not a fundamental right. Under Article 19 of the కాన్స్టిట్యూషన్. సో నేను బంద్ చేస్తాను, నేను బంద్కు పిలుపునిస్తాను అని అంటే అది ఫండమెంటల్ రైట్ కాదు. నేను స్ట్రైక్ చేస్తాను, నేను పని చేయను అని అంటే అది కూడా ఫండమెంటల్ రైట్ కాదు. నేను పెన్ డౌన్ చేస్తాను అన్నా కూడా అది ఫండమెంటల్ రైట్ కాదు. అలా పెన్ డౌన్ చేసినా స్ట్రైక్ చేసినా కూడా అక్కడ ఉన్నటువంటి వాళ్ళు డైరెక్ట్గా వయలేషన్ ఆఫ్ ఫండమెంటల్ రైట్స్ అని చెప్పేసి ఆ పర్టికులర్ మనిషి మీద కేసు వేయొచ్చు, లేకపోతే స్టేట్ అయినప్పుడు స్టేట్ మీద కూడా మనం కేసు వేయొచ్చు. రైట్ అగేన్స్ట్ బంద్ ఈజ్ నాట్ ఎ ఫండమెంటల్ రైట్, రైట్ అగేన్స్ట్ స్ట్రైక్ ఈజ్ ఆల్సో నాట్ ఏ మీన్స్ బంద్ ఎవరు పడితే వాళ్ళు పిలుపునివ్వడానికి లేదు, స్ట్రైక్ ఎవరు పడితే వాళ్ళు పిలుపునివ్వడానికి లేదు. అసలు స్ట్రైక్ అనేదే ఫండమెంటల్ రైట్ కాదు, బంద్ అనేదే ఫండమెంటల్. This is in 2009 or 8 they asked this question. Right to strike is a fundamental right or not? Right to strike is a fundamental right or not? It is not a fundamental right. Right to call for a bandh is a fundamental right or not? It is not a fundamental right. Assembly, see again, doesn't include right to strike. Assemble. Sovereignty and integrity of India and public order, including the maintenance of traffic in the area concerned. So assembly also is having two restrictions. Yes, I can call for an assembly in a lawful manner. It should not impact the sovereignty, integrity of the nation. It should not impact the traffic of the people. Then only I can call for assembly. And calling for assembly also not absolute. With the proper permission from the government, then only I can go for assembly. Allu Arjun issue. That particular movement, road show comes under assembly. He can do assembly. Road show is also called as an assembly, but with proper permission. So by this, a very big case can be called upon him, which is violation of fundamental rights of all the citizens. అక్కడ ఎవరైతే సిటిజన్స్ ఉన్నారో 1000 మంది సిటిజన్స్ యొక్క ఫండమెంటల్ రైట్స్ అల్లు అర్జున్ ఒక్కడే వైలేట్ చేసినట్టు. బికాస్ వితౌట్ ప్రాపర్ పర్మిషన్ హీ వెంట్ ఆన్ టు అసెంబుల్. ఫ్రీడమ్ ఆఫ్ association. Trade unions have no guarantee right to effective bargaining, strike or declare lockout. So we cannot call for a strike, we cannot call for a bandh, we cannot call for a lockout. Earlier what happened in 1960s, 1970s, 1980s లో ఏమయ్యేది అని అంటే కమ్యూనిస్టుల పవర్ ఎక్కువగా ఉండేది, వర్కర్స్ యొక్క పవర్ ఎక్కువగా ఉండేది అనమాట కంపెనీస్లలో. సో వీళ్ళు ఒక చిన్న ఇష్యూ వచ్చినా కూడా బంద్కి పిలుపునిచ్చేవాళ్ళు, స్ట్రైక్ని పిలుపునిచ్చేవాళ్ళు, లేకపోతే లాకౌట్కి పిలుపునిచ్చేవాళ్ళు అనమాట. దాని ద్వారా ఏమయ్యేది అని అంటే గవర్నమెంట్ కంపెనీ అయినా సరే, ప్రైవేట్ కంపెనీ అయినా సరే చాలా లాసెస్ని ఫేస్ చేసింది. ఆ తరుణంలో సుప్రీం కోర్ట్ ఆఫ్ ఇండియా జడ్జిమెంట్ ఏమని ఇచ్చిందనంటే రైట్ టు స్ట్రైక్ ఆర్ రైట్ టు బంద్ ఆర్ రైట్ టు లాకౌట్ ఈజ్ నాట్ ఏ ఫండమెంటల్ రైట్. If you want to call for a right to strike, yes, you can call for a right to strike with the proper information to the management, with approval from the management. మరి మేనేజ్మెంట్ వాళ్ళకి అగేన్స్ట్గా వాళ్ళు ఎందుకు బంద్ చేయమని అంటారు? ఎర్లియర్ ఇట్ వాజ్ ఎ ఫండమెంటల్ రైట్. లేటర్ కేస్ ఇన్ 1970s, Supreme Court of India told in multiple judgments that right to strike, right to bandh, right to lockout is not a fundamental right, but however you can get that, but with proper permission from yes. Freedom of movement. Here we have to understand. Again, I can move anywhere. It is my fundamental right. Freedom of right to freedom. But I am not allowed to move into the tribal areas. I am not allowed to move into the Schedule 5 areas. I am not allowed to move into the Schedule 6 areas. I am not allowed to move into the inner line permit areas in Northeast India. So movement is not absolute, movement is qualified. But however, I am having the fundamental right to move anywhere except few. What are those? Tribal areas. Like Schedule 5, Schedule 6, inner line permit areas, or border areas where military is under the possession, cantonment area where the militaries are under the concession. So means what? So right to movement is not absolute. Again, the right to movement is also speech and association. Speech, assemble, association, movement, residence. Interest of general public, protection of interests of any schedule, right to reside in any part of the country, the right to settle in any part of the country. For example, intamundu when Article 370 was there, we are not allowed to have a home in Jammu and Kashmir. We are not having the right to establish a residence. But after abrogation of Article 370, we can have an residence. Immediately when Article 370 happened, within 10 days, China batch went there. Sri Chaitanya Narayana established there. Come fast. Up to now, they were been waiting when Article 370 will be removed. Why? Because they occupied all except Jammu and Kashmir. Right to establish residence. Except few areas. Like what? Tribal areas. We are not allowed to establish our homes. We are not allowed to establish our residences in tribal. Speech and expression, assemble, association, movement, residence and profession. Few professions are not allowed in public health. Few professions are not allowed, like what? Profession of prostitution, profession of any occupation, trade or business, like profession to do in Schedule 5 areas, profession to do in tribal areas, or money lenders as a profession, they cannot go into this Schedule 5 and Schedule 6. Profession you can do with limited restrictions. Hence, Article 19 talks about right to freedom, speech and expression, assemble, association, movement, residence and profession. Property was there, which was been removed under Article 19, which was removed under Article 31, and now it is part of Article 300 Clause A by which Constitutional Amendment Act? 44. Generally, we will get confusion 42 or 44. It is exclusively 44. ప్రొటెక్షన్ ఇన్ రెస్పెక్ట్ ఫర్ కన్విక్షన్ ఆఫ్ అఫెన్సెస్. ఏవైనా అఫెన్సెస్ జరిగినప్పుడు వాటికి ప్రొటెక్షన్ ఎలా ఇవ్వచ్చు? నో ఎక్స్ పోస్ట్ ఫ్యాక్టో లాస్ అంటే నో ఎక్స్ పోస్ట్ ఫ్యాక్టో లా అంటే నిన్న ఒక తప్పు జరిగింది, ఫర్ ఎగ్జాంపుల్ ఒక దొంగతనం జరిగింది నిన్న, కానీ మన ఏ లా బుక్లోనూ కూడా ఆ దొంగతనము ఒక నేరము అని ఎక్కడ మనం మెన్షన్ చేయలేదు. అరే ఇది ఒక నేరం జరిగింది కదా, ఇలాంటి నేరం కూడా ఒకటి ఉంటుందా? ఫర్ ఎగ్జాంపుల్ సైబర్ క్రైమ్ in 1950, 1960, 1970, 1980, whether we know that there is a computer and that computer will, through computer also we can do offenses, we don't know. సో నిన్న ఒక అఫెన్స్ చేశారు, ఇలాంటి అఫెన్స్ కూడా చేయొచ్చా అని చెప్పేసి ఈరోజు మనకు తెలిసింది. కానీ ఆ అఫెన్స్ చేసిన వాళ్ళు మనకు దొరికారు, కానీ వాళ్ళ మీద మనం శిక్ష విధించుతాము అని అంటే మన దగ్గర ఎలాంటి చట్టం లేదు. అలాంటి సందర్భంలో నిన్న జరిగినటువంటి దానికి ఈరోజు చట్టం చేసి నిన్నటి నుంచి వర్తించేలాగా చేయలేము, విచ్ ఈస్ కాల్డ్ యాజ్ నో ఎక్స్ పోస్ట్ ఫ్యాక్టో లా. ఏదైనా సరే రెట్రోస్పెక్టివ్ ఈజ్ నాట్ అలౌడ్. ఏదైనా సరే ఈరోజు నుంచి వర్తిస్తుంది లేకపోతే రేపటి నుంచి వర్తిస్తుందని చెప్పగలం, కానీ నిన్నటి నుంచి వర్తిస్తుందని చెప్పలేము. సో ప్రొటెక్షన్ ఇన్ రెస్పెక్ట్ ఆఫ్ కన్విక్షన్ ఫర్ అఫెన్సెస్ ప్రొటెక్ట్ చేస్తున్నాం మనము. అలా ఉంటే ఏమవుతుంది? విచ్ హంటింగ్ అవుతుంది. అలా చేస్తే విచ్ హంట్. నిన్న ఒక అపోజిషన్ మ్యాన్ ఇఫ్ ఈస్ డూయింగ్ సంథింగ్ న్యూ, ఇఫ్ ఐ మేక్ ఎ లా టుడే అండ్ ఇఫ్ ఐ టెల్ దట్ ఫ్రమ్ ఎస్టర్డే ఇట్ విల్ బి అప్లికబుల్ అండ్ హి డిడ్ ఎస్టర్డే, సో ప్లీజ్ అరెస్ట్ హిమ్. నో ఎక్స్ పోస్ట్ ఫ్యాక్టో లా. రెండోది నో డబుల్ జుపారిటీ. వాట్ ఈజ్ నో డబుల్ జుపారిటీ అంటే ఒక మర్డర్కైనా అదే శిక్ష, రెండు మర్డర్లకైనా అదే శిక్ష. ఫర్ ఎగ్జాంపుల్ ఒకటే రోజు 2 మర్డర్లు చేశాడు, సో 14 + 14 సంవత్సరాలు 28 సంవత్సరాలు ఇవ్వడానికి ఉండదు. బ్రిటిష్ ఇచ్చేది అలా. బ్రిటిష్ ఏమి ఇచ్చేది అంటే 14 × 10 140 years ఆఫ్ ఇంప్రిజన్మెంట్. సో ఇన్ ఆర్డర్ టు కరెక్ట్ ద మిస్టేక్స్ విచ్ ఆర్ మేడ్ ఇన్ బ్రిటిష్, వీఆర్ కమింగ్ అప్ విత్ ఆర్టికల్ 20 అండ్ దెర్ ఈస్ నో డబుల్ జెపార్డీ. ఒక తప్పుకైనా ఏ శిక్ష ఉందో అలాంటి తప్పు సమానంగా జరిగినప్పుడు కూడా ఒకటే రకమైనటువంటి శిక్ష ఉంటుంది. నో పర్సన్ షాల్ బి ప్రాసిక్యూట్ పనిష్డ్ ఫర్ ద సేమ్ అఫెన్స్ మోర్ దాన్ once. 3 conditions are there. Protection in respect of conviction for offences. Number 1, no ex post facto law, no double jeopardy. Number 3, no self incrimination. తనకు తను సాక్ష్యం ఇచ్చుకున్నాడు అనుకోండి, ఏమని? నేను దొంగతనం చేయలేదు, అది సాక్ష్యం కాదు. నేను దొంగతనం చేశాను అని పోలీస్ కస్టడీలో చెప్పాడు అనుకోండి, అది సాక్ష్యం కాదు. ఎందుకు? దెబ్బలకు భయపడి చెప్పొచ్చు. దట్ ఈస్ కాల్డ్ as no self incrimination. No person accused of any offense shall be compelled to be witness against. Protection against self incrimination extends to both oral evidence and documentary evidence. There should be a third party who should give the evidence but not himself. మనం అనుకుంటాం అతను సొంతంగా ఇచ్చాడు కదా వాగ్మూలం పనికిరాదు, అంటే దొంగకి పనికిరాదు, విక్టిమ్కి పనికి వస్తుంది. విక్టిమ్ చెప్పాడు అనుకోండి, అవునండి వాడేనని చంపేశాడని విక్టిమ్ చెప్తే అది వర్తిస్తుంది. కానీ చంపిన వాడు చెప్పాడు అనుకోండి, అది వర్తించదు. సో ఆర్టికల్ 20 talks about 3 provisions. One is no ex post facto law, second no double jeopardy, third no self-incrimination. 14, 15, 16, 17, 18, 19, 20, now 21. Right to life and liberty. Which article of the Constitution was increasing its ambit like anything? Article 20. Almost everything is coming under the ambit of article. ప్రొటెక్షన్ ఆఫ్ లైఫ్ అండ్ లిబర్టీ. ఇక్కడ ఒక 2 జడ్జిమెంట్స్ మీరు గుర్తుంచుకోవాలి, గోపాలన్ కేస్ అండ్ మేనకా గాంధీ కేస్. రిమెంబర్ దిస్. గోపాలన్ కేస్ 1950, వాట్ ఇట్ విల్ టెల్? ఏం చెప్తుందంటే గోపాలన్ కేస్ 1950 విల్ బి టెల్లింగ్ దట్ ఇఫ్ ఎనీ ఎగ్జిక్యూటివ్ ఆర్బిటరీ యాక్షన్ ఈస్ బీన్ యూస్డ్, if any executive arbitrary action has been used and the person's right to life is violated, is not allowed. But if any legislative action has been used and the right to life has been violated, it is acceptable. అంటే గవర్నమెంట్, కౌన్సిల్ ఆఫ్ మినిస్టర్స్ అండ్ ప్రైమ్ మినిస్టర్ ఆర్ పర్మనెంట్ ఎగ్జిక్యూటివ్ ఏదైనా రూల్ చేసి, ఒక పాలసీ చేసి, ఒక రూల్ చేసి వాళ్ళని అరెస్ట్ చేయండి అని చెప్పేసి వాళ్ళు ఒక ఎగ్జిక్యూటివ్ రెజల్యూషన్ ఇస్తే దాని ద్వారా రైట్ టు లైఫ్ అండ్ లిబర్టీ ఇబ్బంది పడ్డది అని అంటే అది ఒప్పుకోరు. కానీ ఒక చట్టం చేసి ఆ చట్టం ద్వారా అతని యొక్క రైట్లను మనం హరింపజేసామనుకోండి, అది వర్తిస్తుంది. So executive action for the sake of violation of fundamental rights is not valid, but legislative action for the violation of fundamental rights is accepted. Then in Menaka Gandhi case of 1978, the Supreme Court of India told it is not only the executive action but also legislative action. If it is violating the fundamental rights, it is being considered as violation of fundamental rights. Got it? అంటే ఒక ఎగ్జిక్యూటివ్ యాక్షన్ అంటే గవర్నమెంట్ చేతిలో పని అప్పటికప్పుడు చేసేయచ్చు వాళ్ళు. అలా చేసి మీరు ఫండమెంటల్ రైట్స్ ఎవరిదైనా వయోలేట్ చేస్తే అది ఒప్పుకోవడానికి లేదు, గోపాలన్ కేస్. బట్ ఒక చట్టం చేసి వాళ్ళ ఫండమెంటల్ రైట్స్ వయోలేట్ చేసామనుకోండి, అది యాక్సెప్టెడ్. ఏ కేసు ప్రకారంగా? గోపాలన్ కేసు ప్రకారంగా. కానీ ఎగ్జిక్యూటివ్ యాక్షన్, లెజిస్లేటివ్ యాక్షన్ రెండు చూపించి కనుక మనము ఒక ఫండమెంటల్ రైట్స్ కనుక ఎవరిదన్నా వయోలేట్ చేసామంటే అది కూడా ఇన్వాలిడే. So fundamental rights, which is mainly right to life and liberty, cannot be violated either by an executive action or by an legislative action under Menaka Gandhi case. మీరు చట్టం చేసి వాళ్ళ ఫండమెంటల్ రైట్స్ హరింపినా కూడా ఒప్పుకోము, ఒక ఎగ్జిక్యూటివ్ యాక్షన్ ద్వారా వాళ్ళ యొక్క ఫండమెంటల్ రైట్స్ మీరు లాగేసుకున్నా కూడా. సో ద ఇంపార్టెన్స్ ఆఫ్ రైట్ టు లైఫ్ అండ్ లిబర్టీ వాజ్ బీన్ ఇంక్రీజ్డ్ ఫ్రమ్ విచ్ యాక్ట్, విచ్ జడ్జ్మెంట్? Menaka Gandhi case. So held right to life not confined to animal existence or survival, but includes within its ambit right to live with human dignity and all those aspects of life. This is about right to life. This is the ambit of right to life. Fair trial. You have to remember this. Right to livelihood, right to privacy, right to shelter, right to health, right to free education up to 14 years, right to free legal aid, right against solitary confinement, right to speedy trial, right against handcuffing. Right against handcuffing. This all comes under Article 21. Right to pollution-free environment, right to clean water, right to pure air, right to good environment. This all comes under Article 21A by 86th Constitutional Amendment Act. Right to education. Earlier it was part of what? DPSP. Now it has been shifted from DPSP to fundamental rights. From 6 to 14 years free and compulsory education. 86th Constitutional Amendment Act. Which year? 2002. But it got implemented from when? 2009. Then why 7 years? I will tell you. See. Constitutional amendments are just skeletons. Constitutional Amendment Act just it will give a skeleton. When the Constitutional Amendment Act has been created, it doesn't mean that then and there it will be implemented. For every constitutional amendment, there will be a relevant law. So the law is called as the muscles, the skin, the complete body. Whereas Constitutional Amendment Act will just give the structure. So 6 to 14 years of age, free and compulsory education by the state. And midday meal scheme is also part of it. Yes or no? Midday meal scheme is also part of it. But in 2002, it will not come to an application. Why? Because it is just a structure. The complete phenomenon was been not made. Then from 2002 to 2009, they were been making the law, they were been building the law, but they didn't complete to a complete shape because of change in government from 2004 BJP government to UPA government. Then after in 2009, they made a complete law and it was been implemented. It can be GST Constitutional Amendment Act, it can be EWS Constitutional Amendment Act, it can be NCBC Constitutional Amendment Act. Amendment Acts will not just implement. For every Constitutional Amendment Act, there should be a relevant law. So 86th Constitutional Amendment Act was made in 2002, but the relevant law, how to apply it, came into existence in which year? 2009. Right to education. Protection against arrest and detention. Grants protection to persons who are arrested or detained. Two types of detention. One is punitive, other is preventive. When a person does a mistake, and for that mistake, when I am giving the punishment, it is called as punitive detention. Preventive. When this person is going to do the offense, then I arrest. It is called as preventive. So two types of detentions are there. One is punitive detention, other is preventive detention. The wondering thing is, the preventive detention was been made by British. And in that British, now there is no preventive detention. In USA also there is no preventive detention, but in India there is preventive detention. Ordinary law. Right? What is the procedure? Why? Because protection against arrest and detention. When you are arrested, then right to know why you are arrested, right to approach the advocate, right to be placed in front of the magistrate. After placing in front of the magistrate, if the magistrate is not giving judicial custody, then immediately you should be sent free. These are compulsory things with respect to arrest. Under ordinary law. Preventive detention. Detention can extend up to 3 months. More than 3 months, if I want for detention, then compulsory I should get a permission from High Court judge. If not, the preventive detention cannot go beyond it. But however, the 44th Constitutional Amendment Act had reduced from 3 months to 2 months. But it is not implemented till date. Why? Because relevant law was not made. They made a Constitutional Amendment Act, but it is not applied. Why? Because relevant law was been not made. So hence, now also preventive detention is maximum up to how many days? 3. Reduce of detention without advisory board's opinion from 3 to 2, but not brought into force and 3 months continues. Parliament has exclusive authority to make a law of preventive detention for reasons of defense, foreign affairs and security. Both the Parliament as well as the state legislature can congruently make a law of preventive detention for reasons connected with the security of the state, the maintenance of public order and the maintenance of supplies and services essential to the community. Simple. Who can make laws with respect to preventive detention? Center can make, state can make. Who can make laws with respect to complete application of all the fundamental rights? Only Parliament can make. For implementation of all the fundamental rights, for all the fundamental rights, who is authority to make the law? Parliament. Why? I will tell you. But remember this, for application of all the fundamental rights, who can make relevant law? Only Parliament. State legislature will not have the power. But whereas for preventive detention, who will be having the power? Parliament as well as state legislature. For example, rowdy sheeter is there. Is a local problem or national problem? Local problem. If national problem, then the Parliament will come. He is a local who will catch knife and he will fear all the people. For that, central government should come, central Parliament should come for them to control which law is enough. State legislature. If any offense is going to happen, if any communal violence is going to happen, if any big meeting is going to happen, first who will be arrested? Rowdy sheeter. If any robbery happened, first call goes to whom? Rowdy sheeter, local rowdy sheeter. So if any law is to made to control the preventive detention of rowdy sheeter, why? Because he will be prevented. So hence, which law is sufficient? State legislation. One thing we have to understand. Polity will think that it is art, but polity is not art. Polity is also science. For everything there is a reason. But in order to apply all the fundamental rights, we need to make the relevant laws, and in order to make the relevant laws, it is the only parliament who should make the laws. Why? I will tell you later. Right against exploitation. Prohibition of trafficking in human beings and forced labor. Abolition of bonded labor. Abolition of slavery. 23. 24. Prohibition of employment of children in factories. Under Article 24. What are all the legislations? Child Labour Prohibition and Regulation Act of 1986. Child Labour Prohibition and Regulation Act of 2016. These all are to control the child labour. Prohibition of employment of children. 23 and 24. Right against exploitation. 25, 26, 27, 28. Right to freedom of religion. 25. Freedom of conscience, freedom of profess, freedom of practice, freedom of propagate. CPP. Conscience, profess, practice and propagate. Freedom to manage religious affairs. I have the freedom to manage any religious affairs. 27. Freedom from taxation for promotion of it's my wish. State cannot force me to pay the tax for the promotion of a religion. But it is my wish. If I want to, I can give. If I don't want, I cannot. Any person cannot come and ask for Ganesh Chanda. It is not violation of fundamental right. It is violation of fundamental right if it is done by the state. Means police officer come and ask for Ganesh Chanda, it is violation of fundamental right. If a private person is coming and asking for Ganesh Chanda, means you can fight with him. Why? Because he is a private body. But if a police officer is asking for Ganesh Chanda, means maaken leda ante. Article 25. CPP. Conscience, profess, practice, propagate. 26. Manage the religious affairs. 27. Taxation. In promotion of religion. 28. Freedom from attending religious instruction. If it is a government institution, government college, recognized and funded by government, no religious instruction. If it is recognized by government but funded by private, according to the funding pattern, there can be religious instruction, like Christian Medical College. If it is completely private, not recognized and not funded, then their wish. This comes under freedom from attending religious instruction. And last is cultural and educational rights. Article 29 talks about religious and linguistic minorities. Protection of linguistic and religious minorities. Article 30 talks about what? Establishment of educational institutions for minorities. Minorities means who you hear? Religious minorities and linguistic minorities. 30. So very quickly we will do the revision. Tell me. 14. Right to equality, but in that you have to remember equal protection of equality before law and equal protection of law. Article 15. No discrimination based on 5 grounds. Rather than 5 grounds, there can be discrimination by the state. 6 is opportunity of public employment only in 6 grounds. 17. Abolition of untouchability. 18. Abolition of titles. Abolition of titles, how many conditions? 4 conditions are there. Then 19. Speech and expression, assemble, association, movement, residence and profession. Article 20. Protection of arrest, detention for offences. What are those? 3 are there. No post ex posto, double jeopardy, no self-incrimination. 21. Right to left. 22. 2 types of detentions are there. Punitive detention and preventive detention. 23. Human trafficking, forced labor. 24, child labor. 25, conscience, profess, practice, propagate. 26, manage religious affairs. 27, taxation, freedom from taxation. 28, attending religious instructions. 29, linguistic minorities, interest, protection of interests of linguistic and religious minorities. Article 30, permission or for the promotion of educational interests of religious minorities and linguistic minorities. And Article 31 has been removed. Constitutional remedies. See, Ambedkar told, article without which this constitution would be nullity, it is the very soul of the constitution and the very heart of it. Article 32 is a defender and guarantor of citizens of fundamental rights. Supreme Court told basic feature cannot be abridged or taken away by amendment. The right to remedies for the enforcement of fundamental rights of an aggrieved citizen. Understand this. Whether it is following the fundamental rights or not checked in 13. When the fundamental rights are violated, in order to enforce the fundamental rights, we are having medicine by the name called as remedies under Article 32. What are those? Writs. In that writs we have what? Habeas corpus. To find the body. To find the body. To have the body. What is the habeas corpus? Few times police officers, mainly police officers, or we can use the word state will be detaining the people without a proper procedure. Without a proper procedure. So within 24 hours they have to be placed in front of the magistrate. If they are not placed in front of the magistrate, then we can file the violation of fundamental right. Hence there is a need for remedy. For the remedy we can approach High Court or Supreme Court. Under the writ, in order to enforce a fundamental right, the application which I am submitting, the petition which I am submitting with the judiciary is called as writ. Writ is nothing but a letter which is submitted with respect to violation of my fundamental right. So I will ask the judiciary that my brother was being arrested by the police. It had been happened 24 hours, but I don't know why he was being arrested, or he was not put in front of the magistrate. So I have doubt about his whereabouts. So judiciary, can you please take action and find where my brother is? In order to enforce my brother's fundamental right, that is right to life and liberty, I can ask the help of higher judiciary. That particular mechanism is called as habeas corpus. Why this? Because earlier in Rowlatt Act of British, any person can be detained for unlimited time. There is no remedy. So in order to reverse this, we came up with a writ called as habeas corpus. Mandamus, we command. If any public authority is not doing the duty, we can go to the judiciary and ask that this person is not doing his duty. That is called as mandamus. Two things. Habeas corpus. Who can file habeas corpus? Whether a person who is relevant to that person or any random person. Habeas corpus can be filed by any random person. Mandamus, to do the duty, whether the person who is victim or any person can file the petition. Mandamus. Any person. Why? Because, see, it is a public officer who should do the duty. If he is not doing the duty, anyone can impact. So anyone can file the petition. Like that we have to remember. If a public officer is not doing his duty, not only everyone will be impacted, no? So everyone should be given opportunity to file the mandamus. Mandamus. Prohibition. issued by higher court to lower court. When lower court is extending its jurisdiction, when lower court is giving the judgment which is not within its ambit, for example, lower court will not have the power to give mercy petition, to give mercy. But if district court had gave mercy, so it is coming out of its ambit, its jurisdiction. So then I will call for what? Prohibition. Who can call for prohibition? Only higher court. Higher court will call the lower court and prohibit the lower court not to cross the jurisdiction. There is no need for any petition. Higher court can do it by suo motu. Or petition can also be filed. Two things. Petition can also be filed, or higher court can also take the judgment by suo motu. Suo motu means by its own. That is called as prohibition. Fourth, certiorari. To be certified or to be informed, which is issued by higher court to lower court or tribunal either, or transfer a pending case or squash the orders of the latter. Issued on the grounds of excess of jurisdiction or lack of jurisdiction or error of law. That is called as certiorari. On what order you did it? On what power you did it? On excess power you did it. Who will be giving it? Higher order will be certifying the lower order. Who can? Only higher court by its suo motu. Prohibition from either by a petitioner or by a higher court. But whereas certiorari only by an higher court. There is no requirement of petition. If petition is there, well and good. But without petition also it can do. Are you getting my point? So first is what? Habeas corpus. Second is what? Mandamus. Third is what? Prohibition. Fourth is what? Certiorari. Quo warranto. By what authority? The court to enter into the legality of claim of a person to a public office. Sometimes a revenue officer will be working like a police officer. If in British times it used to happen. Or a private player who is locally strong, he will be working like a police. Like what? Moral policing. Moral policing. Like on the day of February 14th, the Bajrang Dal will come and they will catch all the boy and girl who is sitting and they will do the marriage, or they will beat also, or they will arrest also. On what authority you are doing? Who gave you the authority to do moral policing? That comes under which one? QR. Understood that? On February 14th, sometimes some powers will take the power and they act as police. Hence called as what? Moral policing. Moral policing. Many times it happened. Mangaluru, in a pub, when boy or girl both are staying or dancing together, they were being arrested. Bajrang Dal had attacked them. They did lot of moral policing. They were being made shame. Videos were being made. Complete violation of fundamental right. Then quo warranto was released. On what authority you people did? Are you a police? Are you a law enforcement agency? No. At that time, violation of fundamental rights happened. Hence, what type of writ will be issued? Quo warranto. Habeas corpus, mandamus, prohibition, certiorari, quo warranto. Can't be issued ministerial office or private. These are what? Article 32. Certiorari, quo warranto, certiorari as well as prohibition from upper court. Whereas quo warranto, either by petition, only by petition. Petition should be given to the higher court, then higher court will give the order on what authority you people are doing so. Article 33. Article 33 mainly talks about who are working in armed forces, who are working in police forces. They will not have fundamental rights. Recently, what happened, if you remember, in Warangal Mamunuru police camp, in Warangal district of Mamunuru police camp, whereby nearly 10,000 police officers were being installed, armed police. They were being working in the higher, like in IPS officer or in SP houses, they were been working like artillery system. Means all the household works they were been doing. Without any time, without any office hours, without any time limit, 24 bar they are working. So these all people came onto the roads, the police. And they came onto the social media and they told what are the problems they were been facing. 32 people were been suspended. 12 people were been removed from service. So Article 33 of the Constitution will tell that armed forces doesn't have fundamental rights. See, you will think armed forces, yes, they are working for the government. They don't have fundamental rights. It is mentioned in the fundamental rights under Article 33 of the Constitution. If they have any problem, they cannot come out and they cannot have speech and expression. Now you tell me, if armed forces comes under center or state? Center. If any relevant law need to be made, whether state should make or parliament should make? Parliament should make. So if all the fundamental rights need to be, all the fundamental rights need to be implemented, whether parliament should make the law or state legislature should make the law or both should make the law? Parliament only. But because Article 33 only who should do? Parliament. I am using all, no? All means it is only the parliament. Empowers the parliament to restrict or abrogate fundamental rights of the members of armed forces, paramilitary forces, police forces, intelligence agencies and analogous. Martial law prohibits restriction of fundamental rights while martial law is in force in any area within the territory of India. So if martial law is applied, then also no fundamental rights for individuals. Article 33, no fundamental rights for armed forces employees. Article 34, if martial law is applied, then there is no fundamental right for whom? Citizens. So martial law comes under parliament or come under state legislature? Center or state? Center. So who can make relevant law? Parliament, not state legislature. All the fundamental rights, if need to be implemented, who should make the law? Parliament should make the law. Got it? Martial law and martial law and national emergency. These we will discuss in national emergency time. Power to make laws to give effect to certain specified fundamental rights shall vest only in parliament and not in state legislature. Right to property has been removed. Now right to property is what? Legal right. Which is present in the Constitution under Article 300 Clause A. Directive Principles of State Policy. Part 4, 36 to 51. Taken from where? Irish Constitution. Philosophy. It is a philosophy and soul of Constitution. DPSP plus fundamental right is called as philosophy of the Constitution. 36. Definition of state. 37. Directive principles and non-justiciable but fundamental in governance. It is non-justiciable. It is not justiciable. Is present in which article? 37. And it is fundamental in the governance of the country. It is present where? 37. It is fundamental as well as is non-justiciable. Is present in 37. 36 talks about what? Definition of state with respect to DPSP. Article 12 is what? Definition of state with respect to fundamental rights. Socialistic. 38. Remember. 36, 37. 36 definition of state. 37 non-justiciable and fundamental in the governance of the country. 38 to promote people's welfare by securing a social order. 38 remember social order by permitting what? Social, economic and political justice to minimize inequality. What we have to establish? Social order. 39 adequate means of livelihood. Equitable distribution of material resources. Prevention of concentration of wealth. And equal pay for equal work for men and women. Preservation of health and strengthening of children and women. Opportunity for healthy development of 39. 40. Panchayat. Organization of village panchayat. 41. Right to work. Education and public assistance. 42. Provision for just and human conditions. Remember human. Here remember right to work. 43. Decent standard of life. 44. Uniform Civil Code. 45. Early childhood care from 0 to 6 years. Earlier it was from 6 to 14 years. Now it is from 0 to 6 years. 46. Promotion of education and economic interests of whom? Minorities. Welfare of weaker sections. 47. Prohibit the consumption of intoxicating drinks. 48. Prohibit the slaughter of cows. 49. Protection of monuments. 50. Separation of executive from legislature. 51. International peace. Now you tell me. 36. State. You will remember like this. 36. State. 37. Unjusticiable and fundamentals for the governance of the country. 37. 38. Only one word. Social order. Remember only 38. 38 means social order. So social, economic, political justice, no more inequality, then only there will be social order. 39. Adequate means of livelihood, equal pay for equal work comes under Article 39. 40. Village Panchayat. 41. Now 50 completed. Next 51. 41. 41 what? 41. Right to work. Work. 42. Humane conditions. 41, 42. See. Right to work, education and to public assistance in case of unemployment, sickness and disease. 42, just and humane conditions for work and maternity relief. So 41, work and education. 42, humane conditions. Working conditions should be humane. 42. 43, standard of life. Now you see. One grouping. 40 is one standard, village panchayat. 44 is one standard, uniform civil code. So before 40, then 41, 42, 43, then after 44. 40 you can remember. Why? Because it is village panchayat. 44 you can remember. Why? Because 44. 44 means what? Uniform. Uniform civil code. 41 is what? Work and employment. 42 is humane conditions and maternity. 43 is decent standard of living. Then 45. 45. Education. Education 0 to 6 years. 46 weaker sections. Lifelong remember. 46 means weaker. Social and economic benefits of weaker sections. Then 47, 48, 49, 3 we have to remember. Then 47 is what? Drinks, alcohol. 48, cows, slaughtering. 49, monuments. 50 is separation. 51 is international peace. So 50 you will remember. Why? Because separation. 51 is international peace. That also remember. Where we will confuse, 41, 42, 43 or 45, 46. 46 we can remember. Weaker sections, lifelong. 47, 48, 49. 47 is liquor. 48 is cow. 49 is monuments. Now you tell me. 36 state. 37 non-justiciable. 38 is social order. 39 is adequate means of livelihood. 40 village panchayat. 41 education and work. 41, 42 human conditions. Humane conditions, maternity relief. 43 decent work. 44 we know, uniform civil code. 45 what? We know, 0 to 6 years. 46 also we know, weaker sections. Again 47 liquor, 48 cow, 49 monuments, 50 separation, 51 international. In that you can understand what are socialistic patterns. 46 is socialistic pattern, no? 48 is socialistic pattern. 49 is socialistic pattern. Gandhian, village panchayat, who promoted? Gandhi promoted. Liberal intellectual, 44. Uniform civil code, liberal and intellectual. Monuments, 49, intellectual. 50, separation, intellectual. 51, international peace, intellectual. We have new DPSPs. 42nd Constitutional Amendment had added 4 DPSPs. One is securing opportunities for healthy development of children, promote equal justice and free legal aid, steps to secure participation of workers in management, protect and improve environment, safeguard. These 4 are been added by 42nd Constitution. What are been added for? In 39, secure opportunities for healthy development of people. children. 39A, promote equal justice and free legal aid. 43A, steps to secure participation of workers in management. Protect and improve environment. Cows, it comes under cows. 44, what it is added? State to minimize inequalities in income, status, facilities and opportunities. What is that? Social order. 38. Then 86. 45. 0 to 6 years. Which one? 86. Then 97. 43B, which is called as cooperative societies should be formed. Who should promote it? State. Which Constitutional Amendment Act? 97. Under which article? 43B. So how many amendments happened up to now? 42nd, 44, 86, 97. 42nd 4, 44 1 social order, 86 1 45, 97 43 clause B. Why dpsp was made unjusticiable? Young democracy, infant democracy, we don't have money, we don't have resources, so we cannot make justiciable, so hence we made non-justiciable. So when there is conflict between fundamental rights and dpsp, who will prevail? Fundamental rights will prevail. But in Minerva Mills case, the Supreme Court told the constitution was been made upon the bedrock of balance between the fundamental rights and dpsp. Both are important, but when a question comes, it is only the fundamental right which will prevail. Fundamental rights and dpsp. Fundamental duties. Fundamental duties added by 42nd Constitutional Amendment Act on the recommendations of Forensic Committee. Abide by the Constitution. How many are there? 11 are there. Abide by the Constitution. Cherish and follow the noble ideals of freedom movement. So first Constitution, next is freedom movement. One word. First abide or Constitution. Second is what? Cherish and follow the noble ideals of freedom struggle. Second. Third, protect the sovereignty, unity and integrity of the nation. Defend the country when called upon. Fifth, promote harmony and spirit of common brotherhood. Nothing is important. మొత్తం కంట్రీ గురించే మాట్లాడడం. మొదటిది కాన్స్టిట్యూషన్, రెండోది చెరిష్ ఫ్రీడమ్ స్ట్రగుల్, థర్డ్ sovereignty integrity, fourth defend the country when called upon, fifth spirit of common brotherhood. General, nation, constitution, freedom movement, defend, called upon, third is what? Unity, sovereignty, fourth called upon, fifth is common brotherhood. Heritage, natural environment, scientific temper, public property, excellence in all spheres of individual and collective, and last 6 to 14 years, it is a duty. 11 fundamental rights. Fundamental duties. First one, Constitution. Second one, freedom movement. Third, protection of sovereignty, unity and integrity. Fourth, when called upon, to ready to serve the country. Fifth, common brotherhood. Sixth, heritage. Seventh, environment. Eighth, scientific temper. Ninth, public property. 10th, excellence in individual and collective. Last is again 6 to 14 years. I'm telling you, you cannot remember all. Only one word we have to remember. Remaining all we have to understand. But ఆ వర్డ్ గుర్తుంచుకోవడంలో మన స్కిల్ పెట్టాలి. కాన్స్టిట్యూషన్, ఫ్రీడమ్ మూమెంట్, యూనిటీ అండ్ ఇంటిగ్రిటీ, కాల్డ్ అపాన్ అండ్ కామన్ బ్రదర్హుడ్, హెరిటేజ్, ఎన్విరాన్మెంట్, scientific temper, individual collective spirit, strive to excellence. Next, last is 6 to 14 years, public property. Now you say me, fundamental rights can be claimed by citizens alone, yes or no? Citizens as well as foreigners also. Fundamental rights act as a deterrent against despotism of government. So answer is what? D. Fundamental rights act as a deterrent. Who will be controlled by fundamental rights? State. In order to promote what? Individual rights. Second question. Second, please.
B.
Yes.
44. Wrong, sir.
Adi. How many are correct?
3.
Next. See. Both are only parliament. None of the. It's called soul and heart. What is soul and heart? 32. Next. Most accurate. D. Promotion of international peace.
51, sir. 51.
Is it? A is
2, sir.
yes.
Fundamental duties. 4 years at B. B4 is fundamental duties.
Emergency. What is the answer? Again, fundamental rights. 12. 13. Inconsistency with the laws. Judicial review. 14. 15. 16. Public employment. How many grounds? 6 grounds. 17. Untouchability. 18. Abolition of titles. 19. 6. Speech, association, assembly, movement, residence, profession. 20. Against protection against arbitrary arrest. 3. No post facto law, no double jeopardy, no self-incrimination. 21. Right to life and liberty. 22. Preventive and preventive detention. The two are there. Punitive and 23. Human trafficking and slavery. 24. Child labor. 25. Concise, profess, practice and propagate. Next, 26. Manage. 27. Tax. 28. Instruction. 29. Education now. Minorities. Protection of minor. 30. Education. 32. Remedies. How many? 6. 5. 1. habeas corpus. Mandamus. 33. Armed forces employees. 34. Martial law. 35. If any legislation need to be made in order to implement all the fundamental rights, it is the only Parliament. Directly mentioned under Article 35. 36. Definition of state. 37. Non-justiciable. 38. Social order. 39. Distribution of resources, equal pay for equal work. 40. Village panchayat. 41. Right to work, employment. 42. Humane conditions. 43. Decent standard of living. 44. Uniform civil code. 45. 0 to 6 years. 46. Weaker sections. 47. Liquor. 48. Cows. 49. Monuments. 50. 51. Then 11. Fundamental duties. Constitution, freedom fighters, unity, integrity, called upon, brotherhood, heritage, environment, scientific temper, public property, individual and collective excellence. Then last 6 to 14. So you read now. I did my duty. Now you should read till 5:30. Then you attempt the test. Then your fundamental rights and dpsp and fundamental duties will be completed. Tomorrow we will be doing the day 3. Okay. Thank you.